Hello and welcome back to Heights Library's podcast, Unpacking 1619, where you can explore the interviews we've collected with scholars from around the country, in which we unpack topics relating to race in America. I'm your host, John Pichet, and I'm thrilled to share these interviews with you here. Today I'm joined by Tonja Jacobi, Professor of Law and Sam Nunn Chair in Ethics and Professionalism at Emory University School of Law. She discusses her article, Supreme Court Interruptions and Interventions, the Changing Role of the Chief Justice. Recent scholarship has focused on how often the Supreme Court justices get interrupted, especially when female justices are speaking. To fix this, the court changed how hearings are run. This article looks at whether these interruptions and the gender gap in who gets interrupted have gotten better and if the new rules have helped. Here's our conversation from April 18th, 2025.
My name is Tonja Jacobi, and I am the Sam Nunn Chair for Legal Ethics and Professionalism at Emory Law School.
Well, thank you for joining our conversation. We're going to be discussing today your 2023 Boston Law Review article, Supreme Court Interruptions and Interventions, the Changing Role of the Chief Justice. So could you explain how you came to this article? And I know you wrote a previous one kind of doing the same thing, so this is an update. So maybe if you could lay out the whole argument that you kind of did in the first.
Sure. So in 2017, I wrote the first article, and I think we should start there to sort of give context to the latter article. So I wrote an article showing that the female Supreme Court justices are interrupted at oral argument up to 3 times as often as the male justices. And that's interrupted by both the other justices, the male justices, and also by advocates, particularly male advocates. And this raised sort of all sorts of questions about whether female justices' voices are being heard, whether they get to ask the sorts of questions that they're interested in having the court address, whether that affects their ability to form coalitions and make their decisions with full information, etc. So there are a lot of important implications that sprang from that. And it got a lot of attention, that article, which was wonderful, including from the Supreme Court itself. Justice Sonia Sotomayor said that it changed the court, that the male justices, some of the male justices apologized to her and seemed to be changing their behavior, and that the Chief Justice was also changing his behavior by intervening more. And then so she made those comments in the aftermath of the article, and then she made the comments again a couple of years later. And during the pandemic, the Supreme Court changed the way it held arguments. Well, sorry, let me jump back. The Supreme Court, first of all, made one change, which was to introduce what's called the 2-minute rule. And this was the following term. And it meant that advocates would have 2 minutes uninterrupted by the justices at the beginning of oral argument. And I think that was somewhat of a recognition that maybe there was a little bit too much interrupting going on, even though the advocates are actually, part of their job is to be interrupted by the justices, but maybe they should get out at least their introduction. I don't know if that change was inspired by our article, but I think we certainly got the discussion going. And then during the pandemic, the Supreme Court, for the first time in a long time, really changed the way it did oral argument by circumstance that we all know. And essentially, they changed to doing what's telephonic oral argument. So they weren't even using Zoom, they were just using the telephone at first. And they made it such that each justice just got an amount of time with each of the advocates. So it's sort of one-on-one discussion. We did a follow-up article then and showed that even then there was still gendered interruptions going on just by the Chief Justice. The Chief Justice was the only one really interrupting. And he would cut off the female justices, and he would give extra time to certain male justices, notably Justice Alito, his sort of ideological ally in many ways. And so there was a lot of patterns continuing. And then after that, when the Supreme Court came back to in-person oral argument, they kept part of that structure. So they went back to the dynamic back and forth between the justices and the advocates, and everybody sort of throwing in questions as it occurs to them. But then they also kept a structured part at the end. And Justice Sotomayor made another public statement and said that my original article in 2017 was the inspiration for this structure, to try and give each justice some uninterrupted time to make sure they got their questions asked. And that once again, she said that the Chief Justice is intervening more since that article was written, and that things have improved in terms of the female justices being cut off. So instead of just accepting the compliment, I was like, well, I wonder if that's really true, because when I listen to oral argument, I still hear a lot of the female justices being interrupted. So I thought, okay, let's do one more follow-up study, now actually looking at whether things have improved. And so that brings us up to the 2023 study. And in that, we found that in most ways, things have not really improved. So the number of interruptions is as high as ever. The ratio at which the female justices get interrupted compared to the male justices by other justices is still extremely high. I think the second highest from memory in history, but up there, very high in terms of, this disparate effect. And the one thing that we found that had really improved on the interruption side of things was that the advocates are no longer seeming to be gendered. Now, it's early days because we're looking at, since this change was brought in, we only had 1 year of data, but that 1 year of data on the advocate side was really improved. So putting a pin in that and hoping that that continues, it looks very positive so far. The other thing we did in that article is we looked at, is it true that the Chief Justice is intervening more? And the answer is yes, he definitely is. So to give some context, we looked at Chief Justice Rehnquist, the last few years of his reign, and he barely ever intervened. Now, there weren't nearly as many interruptions back then, so maybe he didn't have as much cause. But even in the early years of Chief Justice Roberts' reign, he didn't intervene much. And interestingly, the few times that he did, he intervened usually to give the floor to a man. And so what we show is that in recent years, the Chief Justice has actually intervened a lot more. And the graph is sort of essentially a 45-degree angle increasing over time with the number of interventions. It's still a small proportion of the number of times interruptions occur for him to actually step in and sort of take control of oral argument and say who should have the floor. But the really interesting thing is that when he was asked about my article and asked about how he's responding to that and does he take into account gender, he said that he did not. He said that he gives the floor to the most senior justice. And there are very strong norms of seniority at the Supreme Court. And we thought, okay, well, let's see if that's true. Let's see if Justice Sotomayor is correct that he's really intervening more. We found he is intervening more, but it actually started before our article. So we can't fully claim credit for that, but maybe the continued rise is being encouraged by our findings. And but what the most interesting part is that there is a statistically very clear effect that he is intervening so as to give the floor to a female justice who has been interrupted by a male justice. And so that's very positive. It's not what he says he is doing, but nonetheless, it is what he's doing, and it's pretty clear, the effect. So whether he's conscious of it or not and doesn't want to admit it, or whether he's sort of not even really fully conscious of it, either way, this is what is going on. So there is this positive change, and maybe now in an era where we're paying a lot more attention to women's voices being heard and interruptions not being, allowed to run rampant, perhaps that has led to some of this change. So some positive news, not as positive as Justice Sotomayor characterized it as, but still we'll take the win.
Well, thank you for the great summary of the situation here. I think we should probably begin our in-depth discussion of this by really, because when I listen to, and it's rare that I do, oral arguments, it's chaotic. All is very chaotic. So can you explain to maybe someone who doesn't listen to the Supreme Court so much what the importance of oral argument is, how it's and why these interruptions are noticeable and maybe important?
Sure. Yeah, absolutely. So oral argument is, I think, extremely important, and it's an important thing to study because it is the one part of the Supreme Court's decision-making process that is public. Everything else goes on behind closed doors. So the justices get together, they look at the cert petitions, which are the people asking them to take their case. They get about 8,000 or 9,000 a year. They choose these days only about 60 which to take, and they do that all through behind closed doors. There's a They look at the petitions. They have different justices have different processes by which they do that, but they get together and decide which 60 cases they have, and then it's just announced. And we don't know why they don't take the vast majority of them. And then they read the briefs, and then they come to oral argument, and they have this one public forum, which I'll come back to, and then they go away and they have a conference, which is also completely secret. Not even clerks are allowed, just the 9 justices. And there they give their initial vote, which way they think they're coming out and why. And then they each go into their chambers, and some of them write opinions, and some of them, then they pass things back and forth, and they barely even meet each other all that much. And so the one part of the whole judicial decision-making process that we can actually look at, we can listen to, and we can analyze in a rigorous statistical way is oral argument. And I think that's important because the Supreme Court is making really important decisions about public policy and law. And if we don't know anything about why they're doing it other than their written opinions, which are sort of packaged and meant to be sort of justifying what they're doing, then I think we don't necessarily have that sort of transparency in the law, which is important to the rule of law. And I also think it's very interesting to watch the way that the justices decide issues at oral. You can see them working through the process of oral argument. And I think it's well understood that politics plays an important role in Supreme Court judicial decision-making. But I think part of the value of watching oral argument is to see that the law does still matter as well. So I think it adds to the legitimacy of the court, because you see the justices playing around with different ways in which they could craft a rule. So people ask me, aren't judicial votes all decided by politics? Are you really going to have, an issue like abortion or free speech where the justices convince each other? Maybe not. But what they can do is they can influence each other in terms of how they write the law. The law is not just yes or no. It's what sort of rules should we have? Do we have a standard? Do we have a rule? Do we have a very strict rule? Do we just decide this much now and then hold the rest for future, etc.? So there's a lot of different choice available, even if the outcome is determined by politics, which I don't think it always is. And so seeing the way that the justices try out different ideas on the advocates, well, what if I crafted a rule like this? And how would you respond? How would that deal with these cases? And to actually see them considering different legal options and what the unintended consequences may be of those rules. So I think it's both important that they have this, and it's important that the public can see it.
Well, and it also helped in coding the data. It provided you a transcript for which to look at. Could you talk about how you analyzed those transcripts, how you determined what was an interruption, what was maybe just a stalled point, someone trailing off into the distance, that kind of thing, and then how'd you code it, and what was the data that you coded?
Right, so we have transcripts going back all the way to 1955, and theoretically you could go further back than that, but oral argument was very different even in the 1950s. It was much less interactive between the justices and the advocates. The amount of time that the justices spend talking now is much larger than it used to be. It used to be just all the advocates kind of giving speeches, and then occasionally the justices throwing in a question. So now it's quite different. And so going back to 1955 really gives us a lot of information about how oral argument has changed over time. I also wrote an article about that if you want to hear more about how it has changed. I'm happy to talk about it. And so we are very fortunate in that we have the transcript takers at the Supreme Court are very professional, and they keep a very consistent record of what happens at oral argument. And so they note down which justice is speaking. We have the time stamped down to a couple of decimal points of a second as to when people are speaking and who's speaking. And then one of the things that they note, among others, so they note things like laughter in the court. So I did a study of that, but they also note when there's an interruption. And how they do that is at the end of a line, when somebody is speaking, if they are interrupted, there is a dash at the end of their speech episode. And then the next person who speaks is the interrupter. Now, sometimes there's a dash in the middle of a speech episode, and that conveys when the person speaking perhaps stammers or says a word repeatedly while they're searching for the right word, what have you. So those ones we don't pay attention to for these purposes. It's just when it happens at the end of the speech episode. And so we can essentially write an algorithm to say, find every time there's a dash dash at the end of a speech episode, note who was speaking and then who speaks next. And then you've got who the interrupter was, who the interruptee was, and when it occurred, and how, what happened after that. And so we can analyze in a sort of in a rigorous way who's doing the interrupting, what happens when somebody interrupts, does somebody interrupt back, how long do they get to speak for, when do these interruptions occur, do they occur near the beginning of a statement, or do they occur like a few minutes into a statement? And that might indicate, for example, if it happens really early in a statement, it might just be that two people kind of go to speak at the same time and one of them happens to get there first. Whereas if they're interrupted 2 minutes into a speech, it's probably because somebody's got sick of listening to them. So I also did a study on that and showed actually that if the interruption happens within the first couple of seconds, then it's what we call a crossover. And it's really just people speaking at the same time. And it's often because they're inspired kind of by the same idea. How do we know that? Because we can look at the correlation as to between those two justices who go to speak almost at the same time. They are actually much more likely to vote together on the ultimate case outcome, which is decided after oral argument. Whereas any interruption that happens after a couple of seconds in, the two justices involved are significantly less likely to vote in the same way. And so interruptions, it's a nice illustration how interruptions actually are an indication of conflict if they occur later. But if people are speaking sort of almost at the same time, it's not an interruption in the same sense. It is technically an interruption, but it means something different.
Yeah, and we'll get to the 2020 anomaly probably in this next question, but it looks like in the one article we're discussing, you mainly focused on justice to justice interruptions. So, but you looked at also how advocates or the people who are kind of testifying before them are interrupting the question that's being asked to try to kind of get ahead of the question, the answer. So could you tell us what you found in those two? Well, first describe what justice interruptions look like, and then what the advocates look like and what you found.
Well, so the first thing you should know is that the Supreme Court rules state quite clearly that there should be 0 advocate interruptions of justices. The moment a justice starts speaking, an advocate is supposed to stop speaking. Even if they were speaking and they're being interrupted, they're supposed to yield the floor to the justice. And so it's an actual breach of the rules as to when an advocate interrupts a justice. Nonetheless, what we often see is that some advocates are allowed to get away with it and some are not. And so essentially the more experienced advocates that are part of the sort of the close social network that is the Supreme Court bar are able to sometimes even argue back and forth with the justices. I can give you examples of really, 10 times the justices and the advocates talking, and everyone's talking over top of each other. And that is tolerated to a large extent before eventually the Chief Justice steps in and intervenes. And so that's unusual, but I think that's sort of a recognition that some advocates are just given more deference than others who are generally, and to be honest, they are usually male, not always. They're more experienced, and yet it is clearly an actual breach of the rule. Justice to justice interruptions, on the other hand, are quite interesting in that sometimes the justices, when they realize they've interrupted each other, they will yield the floor back to the original justice, but not always. And so in the original study, we looked at just a year, 1 or 2 years of data of looking at who yields the floor, because there's no way in which that is coded up in an algorithmic sense. We have to hand code and go through that. And we found that not only were the male justices interrupting the female justices, but male justices were less likely to acknowledge when they'd interrupted a female justice than when they'd interrupted a male justice. And interestingly, that was true of female justices as well. So when a female justice interrupts a female justice, she's less likely to acknowledge it as when she interrupts a man as well. And then finally, whether the person is actually having acknowledged that they interrupted to then say, no, you go ahead, that doesn't always happen, even when there's an acknowledgement. And sometimes the justice says, for example, an actual example was, I'm sorry, I inadvertently interrupted Justice Ginsburg. but I really want to make my point, essentially, and keep talking. And that, I think that was Justice Kennedy from memory. And that is sort of an indication here of the sort of the power hierarchy in speech that we see, that, you know, not only who gets interrupted, but who is even acknowledged that they've been interrupted, and then having been acknowledged, whether they actually get a remedy or not. And it's all gendered. And so that says something interesting, I think, particularly about the nature of gender at the Supreme Court. Even like, these are Supreme Court justices who have reached the pinnacle of a very, very prestigious and hierarchical career. Like, there's no higher role that you can have than being a Supreme Court justice within the field of law. And yet still it matters whether you're a woman or not as to whether you get to speak. So that, we thought that was pretty significant, and that said something about the role of women even when they have achieved power. And interestingly, after I wrote the first article, I got a lot of people just contacting me, a lot of people I didn't know, saying, oh, thank you so much for writing this. I have had exactly the same experience in committee meetings, or at probate court, or in magistrates court, or, you know, all sorts of contexts where they see the same thing. And it was very affirming to them to have it recognized that even Supreme Court justices get interrupted in this way.
Yeah, I noticed one of the footnotes was I think it was an article from the Washington, one of the newspapers, and it was like, it doesn't matter how high you achieve, you're still going to get interrupted as a woman.
Yeah, yeah.
Was one of the footnotes I noticed. But I would like to talk about Amy Coney Barrett, because I think you make an interesting point about her, because for the most part, the female justices who have been on the court have been either moderate to left-leaning, and now we have a full-blown conservative female justice. How
Yes.
are you faring in this environment?
That's a great question, because we always had this sort of, as you say, we had this strong crossover between being liberal and being a woman. And so the natural question is, you know, what if it's not about gender? What if it's about ideology? And so we showed that conservative justices interrupt more and liberal justices are interrupted more. And so that would fit with the gender story as well. An interesting side note on that. So we concluded that that was, some people would say, oh, well, conservatives are more domineering or what have you. And we resisted that kind of explanation, because it's like, well, you know, maybe that's true, but we don't know that. We don't want to make a sort of generalization about conservatives. But interestingly, when we did the same study in Australia, where there hasn't been the same period, in Australia, we've had female chief justices, male chief justices, we've had many more, the higher ratio of women on the court, and we see the same thing, that and we have periods where, unlike in America, where the conservatives have dominated on the court since 1969, in Australia we've had periods of liberal dominance and conservative dominance, and throughout all of those eras we still see that conservatives interrupt more and liberals are interrupted more. So in terms of the ideological effect, it does seem to be there's something about maybe a little bit more sort of slightly libertarian aspect of conservatism. I can do this thing unless you stop me, perhaps, is what's going on. I don't want to over speculate. But anyway, so that's an aside. So when Amy Coney Barrett was appointed, it was wonderful from a data point of view, because finally we had a true conservative female justice. Now, Justice Sandra Day O'Connor was appointed by a Republican. She was a Republican. She'd been in Congress as a Republican, in state legislature, but she was very moderate. She was generally at the center of the court. Whereas Amy Coney Barrett is central in the current court, but we have a very conservative court, but there's no doubt that she's definitely a conservative. And so it would be interesting, we thought it would be interesting to look at her in particular. And what we found is that Amy Coney Barrett is interrupted more than the other conservative justices, but less than the female liberal justices. And it's pretty much 50%. So she's interrupted about 50% less than the liberal female justices, but about 50% more than the male conservative justices. And so it shows it's true that there is sort of an interaction between ideology and gender, but they each stand on their own. And she puts her sort of right in the middle.
Well, let's talk about the problem of COVID, because it happens kind of right in the middle of your assessment here, and it changed a lot of the stats you found. So how did you account for it? And first, what did you do? And then how did you account for it?
So to some extent, we have to leave it to the reader to do some of the interpretation. So we make an argument, but we as well as sort of have running our regressions and so on and given the p-values and all of that statistical stuff, we just graph it so that the reader can see for themselves. And so what you see is if you look at interruptions over time, they just continue on an up and up and up slope in the last sort of 20 years or so particularly. But then we see in 2020, they drop down to almost zero because, as described, there wasn't really the capacity to interrupt because it was done on the telephone and the Chief Justice got to say who speaks next in order of seniority. And so if you just sort of ignore 2020, there's pretty much still a pretty perfect line going up in interruptions, in the gender relationship, etc. But our study just had one term after COVID. And so if you looked at the period just after our study blindly, then you could say on average, interruptions and gendered interruptions have gone down because there are only a few years since. Now, we think that averaging is not very sound, even though it would show a huge impact for my work, yay! But that wouldn't be very sound, I don't think. So what we think it's better to do is to just treat 2020 as an aberration, because it was a completely different structure. There wasn't the same potential for interruptions. And then we did a separate study on what happened during COVID, as I mentioned, and showed there was still a real problem there. And so it is up to the reader to look at our results and say, yes, I buy that 2020 is the aberration, not that things have massively improved if we take into account 2020.
Yeah, and you also mentioned in the article about how these interruptions really stifle what could be coalition building, what could be some sort of not consensus, but some sort of interaction which could lead to minds changing. So could you talk about how that these interruptions deter that in some way?
Right. So it depends on essentially your theory of what are the justices doing at oral argument. So if you believe that everything's predetermined by politics, then you might think, well, oral argument's not going to have a huge effect. But as I mentioned, that's not what I believe. I see the justices trying to figure things out, at least in some of the cases. And even in the cases where they're not trying to figure out the outcome, they're trying to figure out the reasoning and the arguments and so on. And so many years ago, before I wrote the first article, when I first started really thinking about this, I actually had a chance in her first year on the court to ask Justice Sotomayor, what are you doing at oral argument? And I sort of said, are you trying to convince people, what have you? And she said to me in a large group, I asked her when I was at Northwestern, we had a forum that she came and spoke at. And she said that she is essentially, she reads the brief and she goes into oral argument with an expectation of where she's likely to come out. She's tending a certain way. And so she wants to ask the hardest possible questions to the party that she thinks she's going to side with. And I'm like, okay. But then I went away and had a preliminary look at the data and I thought, I don't think that's what's going on. And so then the next year I had the fortune of talking to Justice Kagan in her first year on the court. And I said, at a similar forum, I said, look, this is what the question I asked Justice Sotomayor, this is the answer she gave, and it doesn't actually meet the data. Because what I was finding, and this is one of the things I studied in my study on the court changing over time, was that the justices spend most of the time talking to the parties that they ultimately vote against. And I said this to Justice Kagan, and she said what I thought was a very honest answer. She said, look, I'm the most junior justice. And what that means is that after oral argument, we go away and think, and then the next week we meet and we have our conference. And at conference, we talk in order of seniority. And so the Chief Justice talks first and then the most senior justice and down, down, down. And each justice says, as well as what they're thinking, they say how they think they're likely to vote. And so by the time that Justice Kagan, the most junior justice at the time, got to speak, the other 8 justices had already said what their position is likely to be. And so it's very hard to influence them. So she said what she's doing at oral argument is essentially trying to poke holes in the arguments that she has a problem with. And so chances are she is going to talk the most to the advocate that she ends up disagreeing in the vote that comes later. And that is exactly what I showed, not just for Justice Kagan, but for every single justice of the court. So Justice Thomas at that point had barely spoken a word in about a decade, but the few words that he had spoken were overwhelmingly spoken to the advocates that he ended up voting against. And so this is a very, very rigorous finding. And so I think what the justices are doing, getting back, that's a long answer to your question, but essentially what I think the justices are doing at oral argument is they're trying to influence each other. Don't decide it on these flimsy grounds, like decide it this way. And so if the justices don't get their chance to speak and poke holes in the arguments that are really flawed and get to sort of put forward what the strengths and weaknesses are of each side, then they don't get to influence each other in that way. And so that's it's a long explanation, but I think it's really important that the justices being able to point out to each other, because they don't talk to each other very much. Their ability to point out to each other at oral argument what the flaws of a particular approach are is a really important way that the law is developed.
So thank you for that, because I want to ask, and I know you haven't covered in this article, but since we now have Justice Brown on the court, have you seen that there is a race factor?
Sorry, I'm having trouble. I had trouble with that entire question.
Yeah, so, I know it doesn't, you didn't cover it in this article, but now that Justice Brown is on the court, have you seen race as a factor, or have you accounted for that?
So race, I've always wanted to do a race-based study, but the problem is we have very few people on the court to begin with, and we only recently have had really any racial variation whatsoever. So yes, we have one Black woman, we have one Black man, we've had one Black man previously in Justice Marshall. So there's just not a lot of variation. So it would be very hard to say, oh, this is the effect of race. And so one of the things that I would like to do is to look at the race of the advocates, because we have so many more advocates appearing before the court. Now, the problem with that is that we don't know the race of the advocates. It's not like they have to fill out a form at the DMV and put down their race. And so we've looked into different ways to do this. And there are some techniques that are sort of estimates of race. One is to look at names, like there are certain names that are associated with certain races. But once again, the problem is that overwhelmingly, the Supreme Court bar is very white. It's very male and very white and very Ivy League educated. And so we don't have a huge amount of variation in the advocates either. But also we don't have particularly accurate information. So I am sure that race is hugely important, as it is in just about everything, but we can't test it in the same way. But it is it's on my list of things to look into. I think it's tricky to sort of assign somebody a race, especially, as a foreigner, it's, you want to be careful. And so I haven't looked into that. There have been a few studies on this, but it's a much more difficult question to study.
Yeah, I would have thought it was, but I wanted to bring it up. So kind of wrapping up, how has John Roberts done?
Yeah.
Yeah, and what could he do better?
So in terms of these issues that we've studied here, he is definitely a work in progress, but he is making an effort, I think, particularly on the gender question. I think my impression, getting back to the racial question, I think it's much more impressionistic. It's not so data driven. I think that there's certainly more work to be done there by Chief Justice Roberts. I think he's less comfortable dealing with issues of race. And he doesn't necessarily see the way, he's very much well, let's just, if you look at his jurisprudence, his view on race is very much, well, let's just sort of ignore race, be race blind, and that will fix everything. Which, people say, well, if there are power structures that are based on the history of discrimination, then that doesn't work very well. But without getting into that argument too much, in terms of gender, I think the most recent study shows that he is doing something to try and address the problem. I think he could intervene a lot more than he does. The number of interventions that, and I can also talk about how we code interventions if you're interested in that at all. It's not like interruptions that was quite easy to code, just a quick algorithm. But I think he's still intervening in a very small percentage, single-digit percentage of times that there are interruptions. Now, you wouldn't want him jumping in all the time and, being a sort of, autocratic leader of the court. But I think given how many interruptions go on and how it sort of still looks like it's getting worse, I think he could intervene more. But I think he's doing it the right way, just not doing it enough.
Yeah, go ahead and talk about the interventions, because I think that'll give us an idea of what he's doing and why some of it may be working and some might not be.
Right. So, so what we did to look at interventions is there's not just sort of the court reporters don't note, when there's an intervention in the same way. And it's like nobody had ever looked at this question before. We just talked about it in our first article. This is something he could do more. And so, but I listen to a lot of oral arguments, and so I hear sort of patterns. And so what we thought to do is to look at, when does the Chief Justice say something that stops the conversation and makes it clear that he's giving the floor to a different justice? So the first thing we did is we searched for any time he said a justice's name. Now that's going to be way over-inclusive, because sometimes he'll refer to somebody. Justice Alito was arguing earlier, so we don't want to include that. But that's one thing we can do. We can look at whether he says a justice's name immediately after when somebody's been speaking and there's been interruption within a certain number of words, whether that person then gets to speak. But that's saying put justice's name. So, for example, he'll say things like, "I believe Justice Ginsburg had a question pending," or "Justice Ginsburg was next to speak." And so he sort of keeps track a little bit in that way. So that's one of the ways he intervenes. But the other way he does is he says things like, he says certain phrases such as, "go ahead." So if he's interrupted someone, his way of acknowledging and giving them the floor is often to say, "go ahead." But there are instances where he said, what if, for example, your client had said to the market, "go ahead and do this," right? So we had to, so it was a lot of just thinking about ways in which he is likely to acknowledge justice and and then looking at the number of words before and after. And we came up with a list, and then we actually had to go through, after, going through the millions and millions of words in the database that are the transcripts, to then look at the sentence before and the sentence after each potential one to make sure we were actually doing it correctly, which is very tedious. And you wouldn't want to do this study again and again, because nobody wants to spend that much time coding, but we thought it was worth doing this in this case. And so we're pretty confident that everything we count as an intervention is an intervention, but we acknowledge that there's maybe many other ways that we just never thought of. But as long as it's not biased, as long as it's not, well, he acknowledges the conservatives in this way and the liberals in the other, or men one way and women another, which is unlikely. It doesn't matter if you're undercounting, as long as you're counting equal, as long as you're counting fairly. And so he probably is intervening more than we give him credit for, but not so much more that it changes the conclusion that he could be intervening more.
So if you could wave a magic wand and change this completely, how would you structure oral arguments so that it was, no one got interrupted, everyone got to make their point, and so on and so forth?
That is a question I have never been asked. That's a really interesting question, because in some ways, you want to solve the problem that we've been talking about, everybody having a fair say. But you don't want it to kill what is wonderful about oral argument, which is this dynamic process of the justices figuring out what they need to talk about. So during the pandemic, if anybody listened to oral arguments, you would hear just how boring they were. As a spectator sport, it was very tedious. Hearing one justice drone on and talk to one advocate, and then the next justice drone on, etc., just wasn't the same. And so what you'd hear is, so for example, Justice Kagan, who would speak, I think, sixth at that stage, like she had a question related to something that was said very early in the argument, and 40 minutes later she's getting to that question, and it's just not. It was much easier for the advocates to skirt the difficult issue. So it really wasn't as satisfactory in terms of what you're trying to achieve, not just for entertainment for people like me who like to listen to oral argument, but also just in terms of what the justices are trying to achieve. And so I wouldn't like to have an overly structured environment. That's why I say I don't want the Chief Justice intervening every time there's an interruption. Part of the flow, part of the dynamic nature is to sort of see who cares the most and will push a little harder. I do think there are some advantages to having a little bit of structure. So Justice Thomas, since the pandemic, has been speaking. He was always very self-conscious and didn't want to speak and sort of compete for airtime. I think he was very self-conscious for a long time about his accent because he grew up speaking Gullah. And so now he speaks typically first in every argument. Sort of there's this deference that's given to him. And I think, and then he doesn't tend to speak for the rest of the argument. And so that's been a good, force for having everybody's voices heard for somebody who was, not self-confident enough to do it himself. But there's a careful balance to be found. So I used to think, if you'd asked me this question 10 years ago, I would have said, we need more time. Like it's too fraught, everybody trying to get their words in. And I actually don't think that anymore for two reasons. One is oral arguments are much longer now. They've gone from being on average about 60 minutes to being on average about 90 minutes. And they're not as interesting. And I don't think, and that extra half hour, that I think if you were able to count the number of issues that are explored, it's not that many more. The other reason I say that is getting back to my studies on Australia. In Australia, there is essentially unlimited oral argument, or the limits are determined in agreement between the justices and the advocates, and the oral arguments are measured in days, not minutes. And they're on average about 6 days long. And what's interesting is that all of the strategic effects that we showed in the US context, we could replicate in the Australian context, even though there wasn't this desperate sort of fight for time. And so we've showed the same thing, that justices spent their time talking during the time of the advocate that they ultimately vote against, which in the US context had been interpreted as justices trying to use up the time, the very limited time of their opponent, not their opponent, but the advocate they didn't like their argument. But we showed exactly the same thing happens in the Australian context when there's days of argument. And I think what's going on there is that people, especially lawyers, argue with people they disagree with. And it doesn't mean that they're trying to use up their time. It's just that's the nature. You want to poke holes in the argument that you disagree with. And so I certainly wouldn't want to hear days of oral argument. I can tell you that there aren't the same sort of Australian High Court oral argument junkies that there are at the US Supreme Court, because nobody has that much time to commit. And so I wouldn't necessarily add a lot more time either. I actually really like the sort of cut and thrust of the dynamic approach. I think that the Chief Justice could intervene more. I think if we had, quite frankly, younger justices, then maybe there'd be a bit less. I think part of the interruption is, I think older people tend to interrupt more. People who are used to power interrupt more. They think it's their right to speak. People who have life tenure, think that what they have to say is more important. And people who are older tend to be less concerned with, gender power dynamics and so on. So I think if we had more turnover on the court, but that's obviously a much bigger change than you were asking about, then I think oral argument would change a bit. So I wouldn't want to change the dynamic nature, because I think it does something important and it's entertaining. But I would like to see the Supreme Court change and have faster turnover. I think having a bunch of septuagenarians and octogenarians deciding issues of the day is not appropriate, especially after 20, 30 years on the court. They've had their chance to shape the country, and they should move over. And so I would support term limits for the justices. There are disadvantages to that in terms of what will people do after they've been on the Supreme Court. But I think that would be the biggest way to change oral argument for the better. But obviously that's a pretty big change.
Well, thank you for discussing your article. And is there anything you're working on next as far as this topic goes with the Supreme Court? And
yes, so I am working on, I'm looking at the relationship between what the Supreme Court justices say at oral argument and then how that shapes what turns up in their opinions. So most people look at votes and oral argument to the extent that most people, there are a handful of people who do this, but I want to look at oral argument as shaping written opinions. That's the actual law. So I think that's going to be the next frontier.
Thanks for listening to the Unpacking 1619. For more information on Heights Library's 1619 Project discussion group, or to check out more interviews with scholars, please visit heightslibrary.org. See you next episode, wherever you listen to podcasts.